Right, the facts were very unusual, I think, as you've helpfully summarised them. I think it's important to bear in mind that the claimant was the only daughter, so Mrs. Eilert was the only daughter of her late mother. The father had predeceased the mother, but there had been this very long estrangement, as a result of which the mother decided to make a will leaving her estate, which was worth just under £500,000, to charity, to animal charities, expressly saying, I don't want my daughter to benefit from my will and from my estate. There was quite a long court battle, actually. This is the fifth decision we've had in this case, which has culminated in a decision yesterday by the Court of Appeal, in effect saying that the trial judge, who originally, I think it's now 2007, so 7 or 8 years ago, had decided to award £50,000 as a lump sum to the claimant, to Mrs. Eilert, had got it wrong, and that award should be increased in the way you've just explained. I mean,
part of the decision-making process by the Court of Appeal seems to have been based on the daughter's financial circumstances.
Very much so. I think it is very much a fact-specific decision. I think the Court of Appeal, the judgment makes it very clear that all the various factors that the statute requires the court to take into account have to be taken into account carefully on the facts of the specific case.
But by fact-specific, do you mean that this doesn't serve as precedent, that we're not going to be seeing adverts on, you know, mid-morning television for law firms telling us, have you been diddled out of your will, please give us a call?
I can't put the possibility of those adverts beyond doubt. I don't think the case changes the law in any dramatic way. I do lots of these sorts of cases, and I don't think it is a precedent which, for people like me, means the law has significantly changed. I think it is a fact-specific decision.
But isn't there a presumption when it comes to looking at a will that the views of the deceased should take precedence over pretty much anything else?
Not over anything else. The Court of Appeal makes it clear that the deceased's wishes were one of the factors to be taken into account in assessing her daughter's claim for financial provision, but it's only one. As you said, another factor was her competing needs. Another factor was the needs of the beneficiaries of the will, which were charities. And the court said, well, I think slightly oddly, they said charities don't have needs, are not deemed to have needs in a way that is competing to those of a daughter who is in very difficult financial circumstances, which on the evidence she certainly was. So
to essentially draw on some free legal advice here, if I, excuse me, if I wanted to disinherit my children or grandchildren or whatever else, how would I go about doing that? I mean, in this case, there was a letter written alongside the will which made clear that she didn't want any of her funds to go.
Yeah. I think it's fair to say that this case illustrates that it's very difficult to deliberately disinherit someone altogether. Of course, it's fact-specific, so whether the right answer is actually leave the person you want to disinherit something rather than nothing, that might be a solution. It might be that leaving one's assets to another person who is in need, who has competing needs, will make it more difficult for someone to claim in these sorts of cases. I think the short answer is, dare I say it, go and see a solicitor and make a will, because it's very much, the advice will depend very much on the specific facts of the case.
Yeah, it seems awfully strange that you write something, but then the court's interpreted a different way. But then again, we've got to keep you guys in business, don't we, at some point? Edward Hewitt, thanks very much for your time.
Thank you.